Good morning, everybody. Thank you for coming along to this session. We've entitled it Cracking Trusts, Stopping Corrupt Actors and Enablers from Hiding Assets with Impunity. Countries engaged in corruption and bribery investigations often find that when they come to trace assets, they are faced with an impenetrable shield of secrecy when it comes to identifying the ownership of assets. And it's through the help of professional enablers that assets can be held by companies registered in different jurisdictions with corporate shareholders or directors or shareholdings in those companies owned by legal structures such as trusts. And so the purpose of our talk this morning is to try and look briefly at two countries which have faced the challenges of trying to investigate corruption and also turning then to a jurisdiction which has been able to take on the challenge of illegal assets being held in trusts. We've got three panelists here this morning. To my left, we have May De Silva. May is the Commissioner of the Anti-Corruption Commission of Seychelles. She was first appointed in 2017 to an initial 5-year term, and her mandate has been extended in 2022 for a further 5 years. Welcome, May.
Thank you.
We then have immediately to my left, J.C. Welliamuna. He is a Sri Lankan lawyer appointed as a President's Counsel and specialising in human rights and constitutional law matters. He was appointed in 2015 to head the Presidential Task Force on Stolen Asset Recovery. He is the former Sri Lankan High Commissioner to Australia, and he is presently Director of Transparency International in Australia. And to my right, we have Mark Temple, KC. Mark was in private practice on the island of Jersey before being appointed as Solicitor General in 2015. He was appointed to his present role as Attorney General of Jersey in March of 2020.
Yes.
Thank you both as well for joining us. So I'm going to turn first to you, May, if I can, and explain to the people who are here. You're a very busy lady. You've got a clash of commitments this morning, so you're going to join us for the first part of this session, and then you're going to have to leave us. So, conscious of the fact that time is precious, can you tell us about the Anti-Corruption Commission of Seychelles, when it was set up and how it operates?
Good morning, everyone. Thank you, Joe. Yes, and apologies, I can't stay after, but please do leave any questions with Joe if you've got any for me while I'm not here. So, yes, I think one thing before I talk about the setup of the institution, it's important that to note that it is an independent institution. It's not a presidential appointment. It's a job that's advertised, in Seychelles' case, it's advertised openly, and open competition, and a board is interviews the candidates. And in my case, I was interviewed. There were 7 candidates and selected and recommended to the president to appoint me as the head of Anti-Corruption Commission. And yes, so I want to make that point very clear, because the president then, in consultation with the opposition leader, then makes the appointment. And if he doesn't agree with the recommendation, he has to explain why. Because independence of and such an institution is very important. Because I've seen across a lot of jurisdictions where there is presidential appointments, and once the ruling party loses power, then they appoint their own head of institutions. So we were set up in 2017, and my mandate is for 5 years, and then can be extended for 2 terms. So I was appointed by the former president, and then when the government changed, I was then reappointed for a second term. So our mandate is to investigate, detect, prevent, and prosecute corrupt practices. So the setting up process took us about 3 years, and we have a very small unit of investigators for a small jurisdiction, and we have a staff complement of about 42, with about 9 expatriates supporting the institution, because we have a lack of specialists in the Seychelles. And obviously, as a 7-year-old institution, most of our staff are on-the-job training. Thank you.
So, as a new institution, what challenges have you faced in terms of the legal challenges to the institution and the work that you're doing?
Yeah, the first challenge was our act, our Anti-Corruption Act, and it really wasn't fit for purpose. And historically, if we look at why it was set up, Seychelles had ratified the UNCAC in 2006, and then only set up assented the Anti-Corruption Act in 2016, and that's because there was pressure from the funders like World Bank and IMF to set up the institution. So the act itself was rushed through Parliament, and it wasn't fit for purpose. So as we got into investigations and identifying offences, we had to go back to Parliament to have the act amended and updated. And we want to say that they were not. This gave us powers to investigate historical cases and not looking at retrospective offences.
Okay. So I understand that the ACCS is currently conducting a significant investigation at the moment, corruption investigation. Are you able to tell us a little bit more about that case?
Yes, and obviously this case we're hoping will go to trial in January 2025, fingers crossed. But we basically arrested a kleptocrat who was the former, and what the information I will give you, which is already out there in the public domain, because there's been quite some other constitutional cases and challenges to the case. So we arrested a kleptocrat back in November 2021. He had embezzled what we can evidence now, up to about approximately $97 million, which spanned over a number of years from 1998 and in 2002 he actually embezzled 50 million, part of 50 million, which was meant to go to support the Seychelles with its debts, and also to support us in getting commodities while we were going through a very difficult economic period. So that former kleptocrat was the advisor to the former president, economic advisor. And so this took us quite some time to get the evidence. As a small agency, we'd had to rely on our partners. And we also, with looking at the limitations of the institutions, we had to employ some former police officers from the UK and a team of UK counsels as well, as once we'd identified that we could prosecute the case. So now the case is, as I've said, is in court, and we always told that sometimes it's good to have some luck when you are investigating and you've arrested somebody. And our luck was that the person also had a cache of weapons. A couple of months before, the government had put out an amnesty for people to return their guns, and he hadn't done that. So the luck bit is that he is now being held on remand under the Prevention of Terrorism Act. So that's given us some time to collate a lot of evidence. But the other beauty of it was that because he thought he was an untouchable, he had all the evidence in his house. So he kept everything from 1998 in his house. So we had like cassettes, we had like floppy disks, we had all these ancient devices. So, and this case is quite huge for the Seychelles. It's actually bigger than the Seychelles because our national debt is $1.25 billion and our national reserves are $764 million. So this kleptocrat is worth about $1.6 billion. So that gives you an idea with regards to why this case is very important for the Seychelles and for us to now recover all those assets, which now we've discovered he's got them in about over 20 jurisdictions. So that's the challenge for us.
Thank you. So, and I understand that the firearms trial has started and is ongoing, and that trial will finish towards the end of this year with any luck. But what of the challenges have you had, or your institution had, in terms of actually investigating the case? What have been the key issues?
Right. So being a new institution and also small jurisdictions, we have limitations. So we had seized over 800 devices, but the police lab did not have the capacity to do this. So reaching out to our partners, and we had asked NCA UK if they could take the essential devices to try and extract information. And once they realized the enormity that faced us as a small institution, a small country with very limited resources, they loaned us a digital for equipment for a digital forensics lab. So that worked for us because by being on loan, they paid for the licenses and provided the support to the country. And this lab is being managed by two Seychellois workers, and they are on the job training. And in fact, now both of them are the only people in qualified digital examiners in Seychelles because they followed the training and they still working towards getting all their qualifications. So that in itself brought a high volume of documents for us to go through because Seychelles has a very outdated Evidence Act, from the 60s, and that will need amending because the system and the act itself doesn't really fit when we look at all the electronic devices. So it's taking quite a lot of time for us to, for the courts to address this issue as well. So this is one area that's been the biggest challenge because we're working with huge volumes, talking about 10 million documents and having to put in keywords for us to access all this evidence. So far, I think the UK councils have served about 8, 9 or 10 service bundles. So there'll probably be about 12, I understand. So as you rightly say, there is that the weapons trial, because this has given us an opportunity, and through our international partners like IACCC and ICAR, we've been able to get assistance in drafting MLAs, but also to get the support and the networks, their networks, to get the other jurisdictions to respond to our MLA requests.
Thank you. And just in terms, I mean, we're here particularly to talk about asset recovery, and you've already said that Up to 97 million is believed to have been stolen from the Seychelles, and that's in the charges that the individual faces. What are the challenges that Seychelles have had in relation to the asset recovery, finding those assets and seeking to freeze them, etc.?
I think the main challenge, again, like when you are a new institution, is having that confidence to go for the money laundering as well. So if you have a new team of staff and they're focusing on the corrupt practices, so firstly, that's one of the main challenges. But then for you to go to almost 20 jurisdictions and then prioritize which ones are the important ones. And for example, one of the main trusts is based in New Zealand. And so some of the assets are in Singapore, in UAE, in Bulgaria, in the UK. And then obviously the wire transfers were done via the US Federal Reserve Bank. So that brings in the FBI for us. So and takes away the pressure from the Anti-Corruption Commission by having our partners support us. The NCA UK will do that. And then ICAR, because they're the specialists in asset recovery, they've been assisting ACCS in drafting these MLAs, which are like sometimes 65 pages long, because some jurisdictions, will ask you for detailed information, and then you have to send supplementary requests. And our judicial system is not set up for this. You have to prepare your case and it be case ready once you've charged the individuals. So that's why I've said that having the weapons case, has been our luck. That's what's given us the opportunities to go for those assets, to try and recover as much as possible. And we cannot do it. We couldn't have done it without the international partners. And IACCC, we are an associate members. The International Anti-Corruption Coordination Centre, based in the NCA UK, and they have partners across the globe, and they will identify key focal people within those central authorities for us to send draft MLAs to them, so that we can identify those assets as quickly as possible to try and recover them.
Great. Thank you. I'm conscious that we only have you for a short time, and there may be some questions already from, indeed, straight away, for you, May. Mm-hmm. Please, what's your question? Do we have a microphone that we can share? Thank you.
Hi, Commissioner. My name is Neha Wadaker, and I am a journalist. The Cheval Blanc Hotel project in the Seychelles has violated numerous environmental laws, ranging from building too close to the beach where sea turtles nest.
Sorry, I'm not quite sure that this is what we're actually talking about here. We're talking about
it does actually relate.
Commission.
It relates to it. If you let me finish my question.
Well, I'll let you finish your question, but you're not necessarily going to get an answer.
That's fine. I'm happy to ask it and have a no comment. To polluting the wetlands where endangered species live, the Hilton Canopy project has also violated environmental and building law. These are both Emirati development projects, and they continue to be supported by the president despite overwhelming evidence that they are flagrantly polluting and building in violation of Seychellois law. Civil society that I've spoken with allege that President Touavel of the Seychelles is in the pocket of the UAE and willing to sell the country out in exchange for money, gifts, and perks. How would you respond to these?
Can I just stop you there? I think
sure.
This is a topic about anti-corruption in terms of investigations and trying to locate assets that are in different countries. It's not about whatever you've come to raise an issue on.
Well,
there are different forums where you could raise that issue, and it's not the subject of this panel.
I disagree. My question directly.
I accept the fact that you disagree, but I don't think it goes with the subject that we're talking about today. So I'm going to ask that if there's any other questions for the Commissioner, they be asked now.
Can I just say, if you do have a complaint, we have a complaints process, and if there is evidence of corrupt practices, please submit them to the Anti-Corruption Commission, and then we will instigate an investigation.
I was actually in the Seychelles in April, and I tried to meet with you in your office, and my request was declined. So while I realize, I'm sorry, that this is...
Yeah.
I am trying to ask a question about corruption.
But not on the subject that we're actually here to discuss. Okay. So, thank you. Madam, you had a question?
Thank you. Britta Delmers with Public Eye. The Seychelles also sometimes show up as a place where companies are built that then hold assets anonymously, and then the account is in other countries. So it's basically, it's not just sort of the victim of the problem, but also in a way support a perpetrator, and again, hiding assets is enabled through various jurisdictions, and you're one of them. Do you have, and I'm not accusing you of being involved in that or anything like that, but just, do you have, are you involved in advising on what could be done against that, against these shell companies? Is there any movement there, also among countries that are subject to this issue, which then affects other countries as well?
I sit on the National AML Committee. In 2020, the new Anti-Money Laundering Act was assented, 2021, sorry, and also the new Beneficial Ownership Act. And this is to tighten the laws around beneficial ownership. So, which is has a register, and anybody, any company, and any directors owning more than 10% shares interest in a company has to register. And this register is managed by the Financial Investigations Unit, the FIU, and the Financial Services Authority. So any deficiencies we've had with regards to beneficial ownership, that's now addressed under the Beneficial Ownership Act 2021. Thank you.
If I may follow up directly, are you under the impression, I come from Switzerland, and we are in the process of introducing such a register, or maybe not in Parliament now. Are you under the impression that that works well, that public has access, that it really helps the fight, or do you identify gaps right now?
It's not a public register, but any law enforcement can make a request for the evidence that they would need. I mean, it's FIU to FIU or law enforcement to law enforcement, and then go through that process. Thank you.
Great.
My name is Mikhail Boyajev. I'm from Bulgaria, working with the Basel Institute on Governments. And you mentioned Bulgaria just as having problems and issues with AML information sharing. I wanted to share with you that as of April of this year, Bulgaria just established such a type of register for beneficial ownership. So I may actually use this as another tool to solve your issue. And could you share with what is the status of the issue with the Bulgarian AML problems or?
Yeah, we have had cooperation from Bulgaria. We had sent MLA request, and they have prioritized the weapons case, the material for the weapons case, which they did submit. So now we need to do the follow-up for the corruption case, because obviously the individual has a property for portfolio in Bulgaria. So this is an MLA in the process. Yeah.
Thank you. I've got time for one more question. Well, maybe two for the Commissioner.
Good morning. I'm from the African Development Bank, and I have some questions because I heard that you were having some support from different partners. And are you collaborating also with African agencies for example? And are you providing also support to others? Because from what I'm hearing now, you have an extensive experience in asset recovery that could be benefit to other African countries having the same issues.
Thank you for this question. We are part of the African Anti-Corruption Heads Association in the Commonwealth, and that's a forum for us to share intelligence and resources. And so there's a lot of collaboration between Commonwealth Africa, but that doesn't exclude any other country in the African Union. So we do have a lot of information sharing training to in non-Commonwealth African countries. So there is that opportunity for us to share intelligence, information, expertise, and bring in expertise from Africa. I mean, we have 2 expatriates from South Africa working with us. So 3 in fact. So 2 is through ICAR. Yes, so there is a lot of that expertise sharing. I mean, in Mauritius as well, there's a lot of support, and so there is that support within Africa.
And one final question for the Commissioner, for the lady over there.
Thank you. Ears perked up when you mentioned New Zealand from Transparency International New Zealand, and we know that the trust system in New Zealand is quite opaque. So I just wondered if that's a barrier for you, looking at other countries. You know, we've got quite willing financial intelligence units and mechanisms, but with an opaque trust arrangement and no beneficial ownership register. What do you find that that's a barrier, or can you manage to get through the system somehow using your contacts with the police and the serious fraud office and so on?
Yeah, New Zealand is a member of the IACCC, so through them they've been able to coordinate the necessary support. But we do find, there has been some barriers with New Zealand in getting the information. But I think things are moving in the right direction with regards to New Zealand and your trust law and your sector. Yeah.
Great. Thank you. I'm conscious that the Commissioner has to leave us, so thank you very much for your contribution.
Mm-hmm. But can I just respond to your request? I don't personally take complaints, so there is no mileage in you coming to see me. So we have a complaints unit, and there is a process for everybody to submit their complaints. You can go online, you can complete the form and submit your complaint if there is a corruption issue. So we'll gladly look into the complaint. Thank you. And thank you, everyone. I'm so sorry I have to leave. Thank you.
Thank you. I get to turn now. Thank you, May. I get to turn now to JC Williamuna, and to just ask you to tell us from the outset what was the context in which you were appointed as chairperson of the Presidential Task Force on Asset Recovery in Sri Lanka.
Yes, good morning, everyone, and thank you for having me into this quite interesting discussion. Of course, the context of my appointment and context of looking at asset recovery for the first time in Sri Lanka has a political background, because by 2015 there was a complete state capture setting in Sri Lanka. As you probably know, that there was an ethnic conflict and leading to a full separatist war, and the separatist groups were defeated in 2009. Then the government which was in power wanted to get credit of the victory or the euphoria to take the advantage of it, and that they used that advantage into strengthen the family of the rulers. So, and there was oppression, extremely oppressive regime, and probably you have not forgotten that there were 29 journalists killed in 1 year in Sri Lanka, and none of them were investigated. And so to give you that background. So by 2015, there was almost a civil society struggle to replace the government. And then there was a united front in the political oppositions to establish what they called a unity government to defeat the Rajapaksa regime. So that happened in a peaceful election. And in the electoral campaigns, there were two demands primarily. One is to defeat the regime change. Number two is anti-corruption, work. So those were the two. Well, suddenly the government was defeated. Next day, you turn back and see that, okay, how do you fight corruption? Okay. And then you realize that Sri Lanka did not have any sophisticated legal framework, and we were fighting corruption, which is 21st century crime with 18th century tools. I mean, that became a real struggle. So then, of course, the abolition of executive presidency was one aspect. So then came the other focus, fighting corruption and try and locate stolen assets abroad, if any. And there was a lot of credible information even by that time. So then the government was thinking and discussing, and they wanted to have some focus institution which is capable of doing it. And there was no legal framework at all. Then based on the cabinet and the new cabinet, which consisted of, unfortunately, of the new guys who are fighting the regime, and also in order to form a government which is capable of securing 2/3 to change the constitution, they also got some of the cabinet ministers previously served into the cabinet. And immediately, 11 of them became targets of anti-corruption investigations. So you have to understand that that was the context in which the anti-corruption started. Of course, a left foot first approach. Then they wanted to establish a presidential task force to look at the options, and they created this START, which is called the Special Presidential Task Force on Stolen Assets Recovery. So consisting of almost all the investigative agencies, the Attorney General, FIUs, and they wanted to have someone outside the public service to head this institution, to keep independence, and they were looking for, so then they approached me, which I accepted on pro bono basis. So that's the context in which I was appointed, and I managed to look at the legal framework, and we were immediately looking at drafting or getting a consensus on what is called the legal framework on proceeds of crime law, which we did not have then. Of course, Sri Lanka has been dealing with other countries on anti-terrorism front, but except that, there were no major corruption investigations. There were a large number of scandals, but none of them were investigated at that time.
So if I can interrupt you there, what were the main challenges that were facing the task force at that time in terms of and law enforcement agencies? What were the challenges, and how did Sri Lanka seek to deal with them?
Yeah, I think there were multiple challenges. Of course, I can give you a whole list of things. I mean, if I identify flag few, of course, lack of a proper legal framework was one of the challenges. Then the other is lack of expertise. And we had police force of 80,000 police officers, and there was no accountants. No one had specialist knowledge on financial crimes of this magnitude or complex financial crimes. They had to tap somewhere else. And they did not have any experience in drafting MLAs. And for most of the police officers or investigative agencies or anti-corruption agencies, this is something extremely new, which they never have tested. So then the resource issues were there. There was at that time one particular fairly effective crime busting agency called the CID, that's a Criminal Investigations Department. So they were the main anti-crime agency, and they had about 800 officers, about 400 of them were investigators, and each one was handling about 50 to 75 investigation at the same time. So you can expect the delays. And the whole department has only 5 working computers. So then if you give them a bank statement and just to analyze, hardly find an officer who was able to understand, financial track, whether there were anything happening in another jurisdiction and so on and so on. Of course, another uphill battle was the public expectation. You got rid of a bad regime. Now your expectations are very high. People are expecting you to deal with the corrupt elements and to bring back the money on the next week. So that was a big challenge to manage, and because of the very nature of this, you need to start somewhere. And then there was another issue of every time we were looking at the new laws, in the cabinet there was a group consisting of some guys from the previous regime. They were also under investigations on corruption, so they were trying hard to stop it, and sustaining sustaining interest, political will itself is a challenge for any government of that nature. I'm sure Sri Lanka is not the only place for that. So the challenges were that how to secure the expert skills into. Of course, I will come into that, how we secured them later.
So I'm just in terms of the cases that you were working on, were there any particular judicial or legislative challenges that you were facing?
Yes. But there was a very strong judicial challenge in the context of its system. Now, Sri Lanka doesn't allow judicial review of legislation. So you need to challenge a law at the stage of bill in a very limited framework of 1 week. And the judges, and it's been challenged in the Supreme Court, which is the highest constitutional court. And most of the judges came from Attorney General's department. So they had a very pro-state approach, and they were prosecutors, and rarely you get a person with exposure in constitutional law, so to say. So they had a lack of understanding. They have not grappled with big anti-corruption jurisdictions, and the legislative challenges were enormous. Now, I'll give you one example. In Sri Lanka, an investigation into the end of second appeal in a main crime matter can go up to 10 to 15 years. So obviously wanted to have expedited system and introduce an amendment to Judicature Act allowing a trial at bar for specialized complex financial crimes. Now, trial at bar is a context, of course, as you know from anyone coming from the Commonwealth, you know that there is 3 judges specially appointed to hear a case, but it starts day to day and finishes quickly. That raised a constitutional challenge, mainly from the targets themselves and people from the previous regime. And they managed to convince the court that you can't have a trial at bar separately. You can have a trial at bar appointed by the Chief Justice, just like any other trial at bar, and the authority to appoint a trial at bar was preserved with the Chief Justice, and taking away the expected result of the whole introduction. It was stifled to a great extent of there were a number of changes like that. So then ultimately, there were a series of other cases. Every arrest of some, the people in the previous regime, and who were very high-profile targets, they challenged in the court. And And not to mention that almost all the judges in the Supreme Court, Court of Appeal and higher level, they were all appointed by the previous regime. So I was surprised in one particular case where one of the main targets of anti-corruption and killing of journalists was Gotabaya Rajapaksa. So just before he was arrested, the Supreme Court, 3 judges, one judge recused himself, but the 2 judges gave a stay order preventing the police arresting that particular target. That was in 2015 March. Until now, that case remains with an enjoining order. But in the meantime, that target became the president of the country in 2019, and who dismantled the entire framework that was created with so much of dedication. So you can imagine what the challenges can be. Of course, legislative challenges were also there.
What were the challenges in particular in relation to asset recovery in the cases that you were dealing with? You were the chairperson of the Presidential Task Force on Asset Recovery. What were the particular challenges in terms of the assets in your cases?
Yeah. Well, I have to go back to the main issue, the lack of expertise. So we had to look around to get expertise. And one of the main areas, when I was appointed, and myself and the foreign minister, we spoke to all the possible international agencies, the embassies and all that I'm personally spoken to. And I was so happy that our good friend, of course, who is no longer with us, Greta, was first to raise hand and volunteered to help. And that opening gave a huge impetus to our improvement of all the agencies. And we got case mentoring assistance, apart from assistance on reforms. And then all the agencies, including the FBI to Serious Fraud Office to various other agencies, they were all ready to extend the international cooperation. So that international cooperation was one aspect that really helped us to get over some of the main challenges. The legal framework was being drafted. We started drafting, got international assistance. We all had a good group. We raised a good group of experts within the country and from outside. Then MLA was a learning process that also police was learning. Towards the end of 2018, there were about 60 odd police officers who were trained to deal with complex crimes. And they did not have great educational background, obviously, because of the recruitment processes. But they picked up pretty fast with the mentoring processes and being given the freedom to investigate without political interferences. And then there were technical knowledge gaps which they improved through the process. And there were also one mistake which we regret, that there was no way of vetting the police officers in Sri Lankan system at that stage. So because of that, we got, if I may say, in sometimes, people who no one knew their backgrounds, and particularly one senior officer who was later investigated by the agencies, and there was a big case against that guy, and they didn't proceed to for prosecution subsequently, unfortunately. So that was the context, and that was the things. And I think I need to mention that when we realized that we need to have a specialized police unit, Sri Lanka established what is called the FCID, the Financial Crimes Investigation Unit of Police, picked up the people who had some skills in fraud investigations. And those were the guys whom we were targeting for increasing the skills. So one of the challenges was the very establishment of that particular unit. And we knew that one day you have to have a proper law but the police ordinance, the police law, allows establishments of divisions. Now, this FCID was a division established properly, and it is the validity of the establishment that was the basis, the purported basis to stop some number of investigations. And so those are some of the challenges.
Okay, thank you. And I'm going to move on then, having heard about international cooperation and the support that you received. I'm going to turn now to Mark Temple, Casey, as I say, the Attorney General of Jersey, and to talk through an interesting case involving international cooperation where Jersey has helped recover funds that were held under a trust, and the help and support was being provided to Indonesia. Perhaps, first of all, you can just give us an understanding of Jersey itself and where it falls as a jurisdiction in terms of international mutual legal assistance.
Yes, thank you very much, Joe. So Jersey, I'm not sure if everyone knows, but it's a very, very small place. It's between England and France. It's one of the Channel Islands. And we are a customary law jurisdiction, which means that we are a mix of traditional Norman French law, which is our customary source, and modern, often English-derived law, which relates to things like trusts and financial services. We're a very small population, 100,000 people. And in terms of MLA, I'm the central authority for mutual legal assistance requests. So if any of your law enforcement agencies want evidence in terms of how to investigate and prosecute cases, then they approach my office, and we have a team of MLA lawyers who can go and get that evidence. So that's the basic summary.
And Jersey is known as an international financial jurisdiction, international financial centre. It has a well-established trust industry. But perhaps for the purposes of this discussion today, you could just give us an outline of what is a trust? What does it actually mean?
Yes, a trust it's all about a legal relationship. It's not a legal entity itself, it's not a legal person, it's a legal relationship. And it exists where someone who's known as the settlor in the technical language gifts assets to someone else who is the trustee. So the legal title to the assets is transferred to a third party called the trustee. But it's transferred on certain terms, which are usually written down, and those are the terms of the trust, and the trustee has to administer the trust in accordance with those terms. It's usually on behalf of beneficiaries, or it can be for purposes, so it can be for a charitable purpose. And the basic standard form of trust is a discretionary trust, which is normally administered on behalf of the family of the person who has settled the assets. But that's the basic structure of a trust.
And what could be the purposes of trusts?
As I say, they can be for charitable purposes, so Red Cross or Oxfam or large philanthropic trusts, or they can be for business purposes. They can house businesses, or they can just hold assets. They can hold investments, properties, any sort of asset, intellectual property. They're extremely flexible in terms of what they can own.
And in terms of the trustee, the person holding the assets themselves, how does it operate in relation to them? What are they responsible for?
Yes, they are responsible for being in control of the trust. So they own the assets. They should be in control of them. And they have to administer the trust in accordance with its terms. and they have enforceable duties towards the beneficiaries of the trust.
So when it comes to Jersey, are there particular regulations that govern trusts within the Jersey context?
Yes. So Jersey, as a policy decision back in the 1990s, it decided to go for regulation of its financial services industry, and that includes trusts. So the key regulatory statute that governs financial services is the Financial Services Commission Jersey Law of 1998. That's the primary legislation, but there is a mass of secondary legislation issued under that statute as the level of regulation has increased, and it is now extremely substantial, the level of regulation that governs financial services businesses generally in Jersey and trustees in particular.
Thank you. And are there particular regulations in relation to anti-money laundering that the trustees and trusts face?
Yes, so there is, we have a Proceeds of Crime Law, 1999, which is our key anti-money laundering statute, and there is a mass of regulation under that as well. So under the Proceeds of Crime regulation, or law, sorry, if a trustee has, or anyone involved in financial services has a suspicion of unlawful activity, they're obliged to file a suspicious activity report with our FIU, and if they fail to file a suspicious activity report, they can be prosecuted for a failure to do so.
Okay. So that's the background to the trusts. That's the regulation of trusts. But I want to turn now.
There's one further point I ought to mention in relation to FIUs as well. Our FIU, our FIU has a power to consent to a transaction, so they can be approached by the trustee for consent to a particular transaction which may be requested by a beneficiary of the trust, and that consent can be given or it can be withheld, and it's quite an unusual power. And with a regulated trustee, they have an interest in not being prosecuted for a money laundering offence. So if they proceed, if they're not given consent to a transaction, and then they proceed to transact, then they expose themselves to a money laundering prosecution. So where they don't get consent, they will always abide with that, so they will not proceed with a transaction. That's quite an unusual power that our legislation gives law enforcement. We share it with Hong Kong and also with Guernsey, but I think that we're the only 3 places in the world that have that.
Thank you. So I'd just like to now turn to the case that your office was involved in terms of the request that was made. How did you, as Attorney General, become involved in the case from Indonesia? And can you give us some background as to what the case was about?
Yes, so it's a long-standing case, and it wasn't me personally as Attorney General who was involved right from the start. It was one of my predecessors. So in 2009, we received a letter request from Indonesia requesting some evidence concerning a transaction made by Mr. Tantula. And Mr. Tantula, Robert Tantula, was the president of a state bank in Indonesia called Bank Sentry, and there was suspicion that he had stolen assets from the state bank. and that he had settled some of those assets on a trust in Jersey. And it transpired that the money that was settled in Jersey, it wasn't in fact money, it was a property. It was a valuable apartment in Singapore. And the structure of the trust in this case was, again, it was a standard discretionary trust on behalf of his family as beneficiaries. And the property in Singapore, which was known as the Cuscaden residence, it was worth about $7 million. I think that's Singaporean dollars. Was held through a BVI company called Johnsell Limited. And again, that's quite a standard form of discretionary trust. So you have the trustee at the top who holds the assets. It owns shares in the BVI company, and the BVI company owns the property in Singapore. That's quite a standard form of trust structure. So we supplied the evidence of ownership of this trust and what it owned to the Indonesian law enforcement authorities in accordance with our duties under the relevant international conventions.
Okay. So that was when you were initially asked in relation to evidence, or your predecessors were. When and how were the assets, the apartment in Singapore, when was it frozen, and how did you go about it?
Yes, so that was a further letter request that was received by another one of my predecessors. That was in 2013. We were approached with a request to freeze the property, to restrain the property. And in Jersey, that's known as a saisie judiciaire, which follows our French heritage, the language does. And it's a form of restraint order. So
can I just interrupt you there? Properties in Singapore, company that owns the properties in the BVI, trust in Jersey, why are they coming to you to freeze the property?
Well, the reason for that is that the trustee owns the asset. So it's in a position to control what happens to the asset. And that's really the key point of the whole case. Because if you go against the trustee in Jersey, you can lock down assets all over the world because of the jurisdiction that the court in Jersey has over the Jersey resident trustee. It's the personal jurisdiction that the court has over the person who owns the assets. And trusts in Jersey can own assets all over the world. But if you target the Jersey trustee, a regulated Jersey trustee, a professional Jersey trustee, who can be put out of business if it gets anything wrong, then you can lock down those assets for law enforcement purposes very rapidly. And that's what happened in this case. So within weeks of our being approached for a saisie judiciaire, we went to court and we succeeded in obtaining the saisie. So the structure's locked down from that point. And the ownership of the asset is transferred to someone who's called the Viscount of Jersey, which is a very grand title, but he's effectively a court officer, and he becomes the owner of the assets instead of the trustee. The trustee, in any event, as I'd already said, has this. There's this parallel power of an FIU to not consent to a trustee transacting. So a trustee will not transact. But then, as an additional measure, you can go and get a saisie judiciaire, so the asset is transferred from the trustee into the hands of the asset manager, a court-appointed officer who's called the Viscount of Jersey. And so that's what happened in this case. Do you want me to carry on?
Go on, yes.
So, anyway, this was linked to a criminal prosecution that was taking place by this time in Indonesia of Mr. Tantula. So he was indicted of fraud and money laundering offences in Indonesia. He was a man who fought everything, and he had a lot of money to do so, because it emerged that he had stolen $900 million, over $900 million of assets from the Indonesian state bank, Bank Sentry. So he took every single point, and the criminal prosecution in Indonesia, he fought that all the way up to the Supreme Court in Indonesia. In Jersey as well, he fought everything, and as you'll hear, it went all the way up to our highest court, which is our Privy Council. So everything was fought. It took 10 years to fight the Jersey litigation, and in Indonesia it was also extremely hard fought. And as the case progressed, we received, I think it was in 2014, we received another letter request requesting a further SASI, and for slightly complicated reasons, because there was a limit in our legislation at that time as to how far back you could go in relation to transactions. We've amended that and improved it since as a result of this case. But we got another request for a SASI in 2014, so we froze something else. So it was a very long, hard-fought case. Mr. Tantula said that he would rather spend all his money on lawyers than hand any money back to Indonesia. So you can imagine.
So what were the main challenges?
Nature of the litigation.
Sorry.
Yes.
What were the main challenges?
Well, he fought everything, but the main points that went up to the Privy Council. So it was initially in the Royal Court, which is our main court in Jersey. Then he appealed up to our Court of Appeal, which is our only appeals court, and then finally it went to the Privy Council. I dealt with his first point, which was on jurisdiction. So he took the point that because the asset in this case was an apartment in Singapore, and it was held through a company in the BVI, then as a matter of jurisdiction, our legislation did not confer jurisdiction on the Jersey court to freeze an asset that was based overseas in Singapore and then held through a BVI company. So jurisdiction was the first point that he challenged. The second point that also reached the Privy Council was, as the case progressed, there was a mortgage on the apartment which was taken out with Credit Suisse, and he wished to assign the mortgage from Credit Suisse to an old friend of his, Mr. Toscara. And that was the second point that went all the way up to the Privy Council. The third point that went all the way up to the Privy Council was in relation to costs, because he succeeded in persuading the Court of Appeal that there should be a joint and several cost order against both me as the Attorney General, who brought the proceedings on behalf of Indonesia, and against Indonesia itself, so that Indonesia should also be liable for the costs of the proceedings. And so the first point was jurisdiction, that was his appeal. The second point was the assignment of the mortgage. That was my appeal, because he succeeded on that point in the Court of Appeal. And the third point was costs. Again, that was my appeal, because he had succeeded in the Court of Appeal. So those were the three main issues that went all the way up to our highest court.
And so how did if we take each of those issues, how did the Privy Council find in relation to the the issue in terms of jurisdiction.
I'll cut a long story short. We won everything, so we won all 3 points. Thankfully. So in terms of jurisdiction, the Privy Council was quite clear. It looked at the language of our legislation. In this case, it was secondary legislation, some 2008 regulations issued under our 1999 primary legislation to do with enforcement of foreign confiscation orders. It looked at the construction of those regulations, and it also looked at the relevant international conventions, 5 main conventions which are extended to Jersey, and it found that it should give the widest, the interpretation most favourable in accordance with duties under the international conventions such as UNCAC, to give the most favourable interpretation to allow courts, to allow Jersey to assist with those international obligations. So it found that, yes, there is jurisdiction for us in Jersey to freeze, subject to a saisie judiciaire, assets all over the world. And that's a very important finding, because it's now at the highest, it's a level of our highest appeal court, and it means that law enforcement agencies all over the world, if there is an asset that is held by a Jersey trust, you just come to me as Attorney General, ask for assistance, and I can get a freezing order, a saisie judiciaire, and we lock down that asset all over the world. And so it becomes available for law enforcement should a confiscation order be made in foreign proceedings. As Attorney General, I may, in fact, launch my own domestic investigation as well, but we obviously work together with our overseas partners in law enforcement to work out what's the best way of dealing with a particular challenge.
And I'm going to gloss over, if I can, quickly the mortgagor point, because it's not really that central to this case. No. But suffice it to say that you won on that point. But the issue in relation to challenge and in terms of costs was a significant question when it comes to international mutual legal assistance. And I wonder if you could just explain what the issue was there.
Yes, so it is a point of wide application, because it goes really to the smooth operation of our mutual legal assistance regime. And for dealing with cases involving corruption, international corruption, fraud, or those sorts of economic crime cases, which are often international in their scope. Law enforcement agencies are, as we heard from May from the Seychelles, have to go out to many, many jurisdictions all over the world to get evidence to support the prosecution up to the criminal standard. So it is a vital part of being able to prosecute these cases that you get cooperation through mutual legal assistance from foreign jurisdictions. And the idea that another jurisdiction who goes, well, in this case to Jersey, to seek help, is exposed to a cost order for litigation, to me was frankly absurd and repulsive. So it was very important that I challenged that decision of the Court of Appeal, because whilst Indonesia, well, it's the fourth largest population in the world, I think it's in the G20 now, but many of the countries who are seeking legal assistance are not well resourced, and to expose them to a significant cost order maybe many hundreds of thousands, sometimes millions of pounds, was, as I said, absurd. It's just completely contrary to the smooth operation of mutual legal assistance that each jurisdiction depends on. So it's extremely important to appeal that decision. And I'm happy to say that the Privy Council, whose judges also sit on the UK Supreme Court, so it's at the highest level, agree with that. And so, at least as far as common law jurisdictions are concerned, that case is of huge authority, and it means that that countries who approach another jurisdiction for mutual legal assistance are not at risk of costs, unless they choose to submit to the jurisdiction of that particular court. And there is legislation, I'm sure, in most jurisdictions about that. It's in the UK, it's the State Immunity Act, but that's a very, very specific requirements as to how another country submits to the jurisdiction of a foreign court.
Can I ask now then a practical question? You've got your order.
Yes.
You've got your ceci judiciaire. There's the apartment in Singapore. For want of a better way of putting it, how does that apartment become money that can be returned to Indonesia?
So as I said, once the cesi is obtained, the Viscount takes ownership of that asset. The Viscount administers the assets in accordance with the court's directions. And the court can direct the Viscount to liquidate or sell the property. It gave it permission to do so in this case. So the property gets converted into cash. The Viscount owns the cash, holds the cash. And then once the Indonesian order for confiscation gets registered by the court, then that's sufficient authority for the Viscount to send the money back to Indonesia. In fact, but we will deal with that by way of an asset return agreement with Indonesia. We're still waiting for Indonesia to say how they want us to use these, or how Indonesia wants to use these assets. Hopefully it will be for a law enforcement purpose. But that's how the process works.
Thank you. I'm conscious of the time and the fact that a number of people have attended here this morning may wish to ask questions. So this gentleman here has a question.
Thank you very much. My name is Anders Noble. I am with the Tax Justice Network. So I think it's great that you have a panel about trust. I think that's something that's sometimes overlooked. I have two brief questions for you. I've been following the case law in Jersey mostly. I mean, I can think of quite problematic from my perspective, cases like the Sheikh Fahad Mohammed Al-Sabah, Esam case, Benhis, where the courts in a way find that the trust remains and whatever the parties did is in a way fine, and it's very hard to do the asset recovery or just to pierce the trust or to go against the trust. Is there any case law in Jersey that is similar to the Pugachev case in the UK, where the judge said, you know what, you might be the protector, you might just pretend not to be anything, but in real life, you are the one calling the shots, you're controlling everything. So we will disregard the trust and really understand that you are actually involved, and then that means that creditors or authorities can get access to the assets. So is there anything in Jersey going towards that side where the trust is not really upheld, either because it's a sham or even because they say you can put on paper whatever you want, but in reality, there's something else? That would be the first question. And the second one has to do with discretionary trusts. I mean, you mentioned that they're quite common in Jersey, and I would agree with that. I find them extremely problematic from two perspectives. On the one hand, from a secretive perspective, if you have discretionary trust, many laws, even the OECD sometimes might say, the object of power do not even need to be identified. Only wait until there's a distribution. Until then, no need to identify any potential beneficiary. They may end up not receiving anything at all. On the other hand, there's the asset recovery problem, or the asset protection side, which is the settler says, the assets are in the trust, I no longer own them. The beneficiary says, they're not mine yet, I have to wait for distribution, that may never happen. And the trustee says, well, I am the legal owner, but they don't belong to me. I cannot do whatever I want. I just have fiduciary duties. So in a way, they're in what we call this ownerless limbo, where like everyone can use the house, the yacht, but on paper, no one owns them. How do you find discretionary trust? I mean, even when I ask people, what is the legitimate use of that? I hear cases of asset protection, tax avoidance. I mean, I cannot think of any good use that really helps society other than giving flexibility. What is your view on that? What is the view of Jersey courts, or how do you think, can a discretionary trust be considered like a risky case? I mean, I know in some countries like Switzerland, even France or Spain, they say for wealth tax purposes, even if you have a discretionary trust, I will assume that the wealth belongs to the settlor. I don't care about the trust. Do you see any of that, or would your as an Attorney General, be promoting any of these cases where, like, discretionary trust, on paper you might say whatever, but reality is hardly that case? So I would really like to hear your views on that. Thanks.
So I think there's two questions there. The first was about sham trusts.
Sham, or any case so similar to Pugachev, if there's anything like that in Jersey happening.
I'm happy to answer both questions.
Yep.
So in relation to the first question, sham trust is normally a private law concept rather than a public law criminal concept. And because we have a regulated trust industry in Jersey, that is a very, very high hurdle to get over, because where you have a regulated industry, the trustee, this is not some sort of private individual, these are quite large organizations, and they are in control of the trust assets. Where it's a discretionary trust, they have their own discretion as to how that trust is administered and who benefits from it. So it's a very high hurdle to get over in the case of a regulated trust industry. So we have a private law trust case called Esteem, which dates from the early 2000s. I think it's about 2003, where in that case, yes, there was a finding of a sort of sham. That was on quite unusual facts, but there is that possibility of a sham trust. But as I say, it is a very high hurdle to get over, where you have a regulated, in many cases, corporate trustee that is administering the trust.
And just by a sham trust, what we're talking about is a
trust,
but a trust that is a trust in name only. It's created.
Yeah,
it's false.
Basically it's a false document. So the terms of the trust that may be written down are essentially false. That they don't mean what they say. So that is a very high hurdle to get over. It has succeeded in one case, as I say, back in 2003. But that's a civil law remedy, or private law remedy, rather. In terms of law enforcement, that's a separate jurisdiction. And as I've just said, for law enforcement purposes, we can enforce against trusts. And all you have to prove is that the money that went into the trust is the proceeds of crime. Or if it's a tainted asset, there's another way we get at it, and that's under civil forfeiture. If we can't prove it to the criminal standard, then we will go with civil forfeiture. Our civil forfeiture law is fairly recent. It's from 2019, but we've effectively used it now in a number of cases, most recently in relation to a case involving Mozambique, where we have returned money to Mozambique in Mozambique's first ever asset return in the world. And so that's another way we get back tainted assets. So it's just a case of, and under our civil forfeiture law, again, probably common with other jurisdictions, we reverse the burden of proof. So the person who has settled the assets has to prove that they derive from a legitimate source. And we've done that in a number of cases, so Mozambique to Nigeria as well, we've done that. And we have other legislation concerning civil forfeiture, which allows us to recognize foreign civil forfeiture orders. So we did a big case with the US and Nigeria where in relation to Abacha monies, General Abacha, where we've returned over $300 million to Nigeria as a result of recognizing a civil forfeiture order that was made in the US courts against companies in Jersey, and we've returned those monies to Nigeria. And they've been used to construct the second Niger Bridge and for various infrastructure projects in Nigeria. So that's the first question. So in relation to your second question, which...
discretionary trusts.
Discretionary, sorry, just remind me of it again. So
well, it was the issue of discretionary trusts and the fact that the settlor says, well, these aren't my assets.
Oh, yes. Okay.
I'm holding them on trust. And the beneficiaries say, well, they're not ours either because they're held in the trust. We don't have the right to them at this stage.
Well, I think look, there are private law remedies in trust law as which govern relationships between the trustee and the beneficiary, and the trustees have fiduciary duties, and they can be sued for breach of trust if they don't comply with those duties. So that's the private law remedies. The public law remedies basically come back to what I was just saying earlier. If you can prove that they're the proceeds of crime, then you come to me and you ask for legal assistance, and we go about gathering the evidence to prove the transactions between the settlor, the man or woman who made the money back in whichever jurisdiction it happened to be. We have to trace those monies to trace the transactions, to link the money with the trust, and that gives us our connection.
Can I?
Yes. Sorry.
Or if we can't do that, then we use civil forfeiture.
No, sorry, there might be other questions, but just to respond to that. So, actually, in the Benkis case, there had been actually.
Sorry, which case?
The Benkis case is about like illegal fishing in South Africa.
Right.
It was a Jersey trust, and so the settler who was actually accused by South Africa and they were supposed to pay. I mean, they paid the U.S., but then when South Africa asked for the money, they said it's in a trust. So the settler then kept changing, and then he became a protector. And then, basically, the point was that he had full control over the trust. He had even received things, but the court said he's not a beneficiary. Under no way he would be a beneficial owner to this. He's not a beneficiary. He's just a protector. So the money remains in the trust, even though they had proven that it was illegal money from the illegal sales in the U.S. that went into the trust.
Which court was this?
In Jersey. I mean, I can then send you, but it was like two different cases in Jersey. But the FIU actually blocked the money, but then they said, there's nothing to block here. I mean, I'm not the owner. I'm just a protector, and then he stopped being the protector.
Well, we have enforced against that, and we have returned the monies to South Africa. So we have confiscated the proceeds of crime in that case. So I'm not.
I think not in this case. I mean, we can go into details. But then there was another one where, again, even there was this Sheikh Fahad. The embezzlement happened before then. After the trust. So basically what the court said, by the time you settled the trust, it was clean money, and then you did the embezzlement. And there's like the wife and the children, there are other beneficiaries, not just, even though the settler controls and he's a potential beneficiary, he's not the only one. So the court said, I cannot say that this is tainted money because you settled that before that. Now, had the money not been in a trust, I mean, no matter when you did the embezzlement or what you inherited, you have to respond with all your money. I mean, it doesn't matter when you got it what. If you owe money because you embezzled, you have to pay that. But the Jersey court found, well, it's in a trust. The trust was settled before the embezzlement. That remains. So the interesting case about the Pugachev case was that, again, I know the sham in the UK and maybe in Jersey is too high. You have to prove that it's actually false what they're trying to do. In other cases, sham, I think even in the US, is more about reality doesn't really match what the paper says. I mean, maybe the trustee and the settler are all in it together, so it's not a sham. I mean, they're doing what the trust document says, but in reality, I mean, reality is quite different from that. So the UK had advanced in that, and I was wondering, because I understand that it's great that Jersey is helping cases like Indonesia when everything is found to be okay, and then you freeze the assets. But what happens when the problem is the trust itself? And I know that you have provisions about when beneficiaries fight with the trustee, but what happens when they're all in it together against society, against tax authorities? I think that's where Jersey courts, I found, have been quite problematic in protecting the trust and saying, well, it remains. There's nothing illegal here, you cannot prove that, This is just a protector, not a beneficiary, even though he has full powers. And they said he even got a benefit. This was the South African case. He even got a benefit, and he said, then say it's a breach of trust. This doesn't prove that he's a beneficiary. It's just and it's like, come on. I mean, it's so those questions.
I think that's the question. I think a brief response in order to, in case anybody else has any other questions.
Well, in law, it's about what you can prove. And you have to have proof in order to deprive someone of property. And if you don't have the proof, then we can't do anything about it. But if there is the proof, we can go back with gifts quite a long time before the offending behaviour now. So I think the Sheikh Fahad case that you referred to, that's quite an old case. Our legislation now has been improved quite significantly. So we now can go back quite a long way before the offending behaviour. So I think, but civilized society does require fair legal processes. And in order for there to be a fair legal process, you have to have proof, you have to have evidence. And our courts do respond fairly to evidence. I mean, I think that's probably about as far as I can go. Thank you.
We have another question from a lady at the back over there.
Hello everyone, my name is Zeliha and I'm from Nigeria. I work with Connected Development, and what we do is to empower marginalized communities to hold governments accountable. And I like that you mentioned the Abacha loot, and that's where my question is from. We're talking about trust here and also talking about enablers. And my question is, what happens to enablers of corruption? We have seen a lot of policymakers from Global South, and now we're talking about political actors. They siphon money, take it to the world powers like the UK, the US. You talk about France, Switzerland. And these are where, up to today, Nigeria is getting money from the Abacha loot. Just to mention, he died in 1998. That's a whole lot of years ago. So what do we have? Do we have a sort of regulatory framework, a financial regulatory framework that would help? Yes, we know we in Africa, and maybe Nigeria, for example, we do not have very strong regulatory framework. What do we do as people here on the table? What do we do to ensure that the enablers, the world powers, also have some sort of financial regulatory framework? So when this money is coming, how do you know if this money is legit? It's clean, to use that word. And our monies don't end up in these countries. Probably they use it, turn it for their own development, and after a few years we hear that Abacha loot is coming and we are told how to use the money. Again, these are monies that were stolen from Nigeria, and today we are underdeveloped. Again, I work, like I mentioned, we work with communities, young people.
Could I ask you to ask your question?
Yeah.
Because we're very, very short of time.
Yeah. So how do we, and I'm going to use trust and as an adjective here. How do we build trust and tell young people, you know what, you can hold your government accountable. You can trust the international community. When the world powers, UK, US, France and the like, have continued to also enable our actors to become corrupt or siphon money to these countries.
Okay. I mean, I think extrapolating from that in terms of what you could answer, what are the regulations in terms of trusts? You've already said in terms of anti-money laundering regulations, receiving monies.
Yes.
Anything further you can add to that?
Well, I would recommend that Nigeria invests in a strong regulatory framework concerning people like trustees, lawyers, accountants, anyone involved in the financial services business, and imposes rigorous requirements on them in terms of how they investigate the source of the assets in question to prove beneficial ownership, to prove that they come from a legitimate source. As I say, in Jersey, we went for that model in the late 1990s. Our level of regulation is now very, very significant. And I would recommend that as a model to other jurisdictions, because look, your reputation is of fundamental importance, and if you change that reputation, you will find that your business, the level of corruption will reduce. Business becomes better, the quality of life for citizens becomes better, and the level of corruption reduces if you have that level of regulation.
Well, thank you for that response, and thank you to both of our speakers, in fact all three of our speakers this morning. We've heard about the difficulties that states face when they're dealing with complex corruption investigations and how to trace assets located abroad. And we've also heard how some jurisdictions can actually take action against the legal structures within their own jurisdiction within which assets are being hidden or concealed against seizure by other states. We have literally now run out of time. I'm sorry that there's perhaps more people who wanted to ask questions, but I'm sure our speakers will be available afterwards to answer any questions you may have as well. But thank you all for coming.
Thank you.